Hello and welcome to another Legal Talk one-on-one exclusive interview on complex business law issues. Counselors, let's get right down to our first business law question that has to do with practicing in today's economic climate. As business attorneys in Los Angeles, how would your approach to litigation benefit a business or individual faced with a business dispute such as fraud, unfair competition, or breach of contract?
First and foremost, in today's climate, you're not going to avoid litigation. Whether you're a solo practitioner, an LLC, or a corporation, at some point you're going to be faced with litigation. Gone are the days of throwing a bunch of different legal claims against the wall to see what sticks and to draw out the litigation process. That process is very costly and very inefficient. That's why we focus our litigation practices on surgical litigation, meaning we don't waste everybody's time. We don't throw legal issues against the wall to see which issues will stick. Instead, we focus on the real issues.
And just to draw on an example, the discovery portion of the lawsuit is usually the most costly for the client. And the discovery portion is the evidence gathering and information gathering portion of litigation. Our approach to discovery is very narrowly tailored and focused towards those one or two legal issues that are most germane to the lawsuit itself. So, for example, instead of the shotgun approach where we're trying to get everything under the sun, our evidence gathering and information gathering is focused and narrowly tailored to strengthen and maintain those legal issues that are most germane to your position.
Well, it sounds like you definitely take a very unique approach to your clients' legal needs, but potential business disputes, can they typically be avoided through carefully drafted contract provisions?
The short answer is no. However, having dealt with countless dispute scenarios over the years, we've learned to identify the situations that are most likely to cause disruption amongst a partnership or third parties if you're a solo proprietorship. So in real life, when this dispute comes up, what you would do with your business associate or a third party that you're dealing with is simply refer to the contract to resolve the dispute so that you're not spinning wheels and dealing with an issue that could have been dealt with very early on. Now, this is not to say that a carefully drawn contract in all cases will help you avoid litigation, but it will reduce the likelihood of litigation, and if litigation is to arise, we will be able to deal with it much more efficiently.
Good advice, Counselor. Now, considering business-to-business commerce is fully integrated with the internet, what are some legal issues Los Angeles business owners need to be mindful of when conducting business online?
There are two issues that we've seen come up over and over again: jurisdictional issues and issues of trademark infringement. With respect to jurisdiction, the traditional notions of jurisdiction are out the window. With the internet, you have global reach. In other words, you can be a business in Los Angeles and continuously be doing business in New York. Now, you can be subject to New York's jurisdiction because of your contacts and the continuous and systematic contacts you have with a business in New York. So we advise our clients to be mindful of those issues and be aware of them. Another issue that seems to be coming up more and more often is trademark infringement, which occurs online. Now, we've seen trademark infringement happen more and more often online, and we've seen it happen with respect to cyber squatting, which is the buying a domain name by a third party that incorporates your protected mark. Now, we've dealt with those cyber squatting issues for our clients, and we're able to problem solve and retrieve those domain names for clients. But what we've seen with trademark infringement happening more and more often is with respect to pay-per-click advertising and internet search marketing. Now, what we've seen are third parties using the pay-per-click model within the search engines to essentially bid on traffic that incorporates a client's protected trademark. And we feel that that isn't necessarily legal, and it could be a violation of the Lanham Act. And we provide these type of consulting services and legal advice with respect to trademark infringement for our clients.
Thank you, counselors, for your legal input today. And our hope is that this information has been very informative for you, the viewer. My name is Milton Lawrence for Legal Talk One-on-One. Thanks for watching.